They have been doing our bankruptcy training for many years. They are pros at this, and they are the people to ask questions to. They also are very generous in any follow-up questions. If you take a bankruptcy case, David is always willing to mentor you, answer questions, give you some advice on which way to go. So without further ado, let's welcome our speakers.
Thanks.
All right, let's see if I can turn this on. It's on. All right, although I have a booming voice anyhow. So I'm David, she's Kris.
Yep, hi.
We, in a way, sadly realized this morning that between us we have over 62 years of doing this and experience, and that's kind of sad in a way. And we represent primarily debtors. Our firm solves financial problems for people, and so our bias, my biography is in the materials. Is yours in there too?
I'm not sure.
Okay, but you'll see my bias. I'm generally representing people that owe money. That's what we do. Not all. It doesn't have to be indigent people. We do all kinds of things. Anything that if it involves debts, it involves us. And I'll be happy to take questions today. So will Kris on anything related to debts. We like to make these programs what you want to learn out of them, not necessarily what we've set up as your agenda, because we know you encounter different things. So we will take questions throughout the morning. Anytime you have a question, in fact, I like questions so much as opposed to me talking that I will bribe you in order to get questions. How many of you have been to one of these before, a bankruptcy? Oh, you already know about bribes. All right. And who wants a candy bar? All right. Okay, well, you'll get a choice this year. We not only have candy bars, we have fabulous prizes this year. So the bribes are going to be really great. Maggie correctly said that we are always willing to help you with your cases. We feel that one of the things we can do, VLP is one of our favorite projects. We think it does great work. Maggie and I are already talking about new ideas, ways we can get the word out even more. So we do make ourselves available. If you take a case and you have a problem with it, call us. We will buy you coffee and a donut to talk about your case. You have to come to Madison or somewhere close though. But we'll talk to you over the phone. We're happy to do anything we can. And I can tell you, Maggie, that every year we get more people taking us up on that offer. So I'd like to do at least one a week this year if you had enough cases to do. Let's see. This is being videotaped today. We don't know how this will turn out because we've never done this before, but we're going to try to make this available to you afterwards because I know that it's hard to take all your notes while you're talking and that. So we're going to try to find a way to put this on our website and make it available to anybody who does VLP work. I don't know how that'll work yet, but Maggie can probably email everybody once we get it up and done and figure out how that's going to work. You're also welcome anytime to come to our website. It's a slowly developing website, but I'm getting more and more frequently asked questions on there about bankruptcy. I have a blog with bankruptcy things. If you ask me a question, I will put it on the blog and let everybody know without knowing that it's you who asked. I will put that on the blog. I'll answer it and put it in writing for future posterity.
It's hard to send a candy bar through the...
I'll even get you a candy bar. We also put out a newsletter every month, and you're welcome to sign up for that. Just give us your business card, write newsletter on it. If you'd rather meet with one of us in person and pick our brains about anything related to debts or even practice management or ethics, those are the only 3 things I talk on. Put breakfast on there and we'll try to arrange that for you. Okay, remember that's on our nickel. So we got a lot to cover here this morning. Last Friday I spent 2 hours at the Department of Agriculture teaching them about Chapter 12. And we're not even going to talk about Chapter 12. Chapter 12 is just this little tiny sliver of bankruptcy. So if I can ramble on for 2 hours about Chapter 12, I ought to easily be able to cover 3 hours on everything about bankruptcy. So let's start with, why do people even come to us for help? And there's a lot of reasons. Unemployment, divorce, disability, car accidents, misuse of credit. There's a lot of reasons why people get into financial trouble, and you're going to run into all of those. The problem is that those occurrences lead to things like repossession, foreclosure, lawsuits, garnishment, and that's when people come to you for help. So what are you going to tell them? We may be talking about bankruptcy here, but bankruptcy is never where I start. Okay? In fact, I often will tell people, come into my office and I'll say, I'm not a bankruptcy lawyer. You're not? No, I'm a problem solver. And bankruptcy is just one of the many tools in my arsenal to solve your financial problem. And you have those same tools. So if we think about what the various tools are that we have available, sometimes it's do nothing. There are instances where people don't need to file bankruptcy. I see them all the time. Elderly people come in, they're on Social Security, they have no assets to speak of. They don't need a bankruptcy, but they might still want a bankruptcy. Oftentimes the kids will come in, the whole family will bring mom along, and you know, she's getting these harassing letters, she's very upset. Bankruptcy may be an answer just to stop the harassment because the mental benefits from it are worthwhile. But do nothing is often an option for a lot of people. And in fact, a lot of times we need to do nothing for a while just to get someone ready for a bankruptcy. Then there's always litigate. And litigating with debt collectors can be a lot of fun. I don't know if anybody here does any FDCPA, Fair Debt Collection Practice work, or Wisconsin Consumer Act work. I love that stuff. In fact, just yesterday, we discovered that one of our clients is going to get a free car. A free car! Why? Because, I can't remember who the creditor was, repossessed it improperly. They gave the notice that they have to give in order to repossess. We sent a letter in saying we object. They still picked up the car. So my client is going to be really, really happy because the benefits of an illegal repossession in Wisconsin are you get the car back, you get back everything you paid, and you get all of your attorney fees. So I'm going to be really happy too. Okay. So sometimes litigating is a really cool, leads to really cool results. Then there's settlement, of course. And for a lot of people, that's a good strategy. They don't have much. Creditor realizes the old, you can't squeeze blood out of a turnip, and you can settle things for pennies on the dollar. Be careful when you're settling. Be sure you consider the tax consequences. There can be adverse tax consequences. And even if we're dealing with people with very limited income, a large debt cancellation could result in a large tax bill. So $100,000 worth of written off debt can be $100,000 of ordinary income, and that can put you into a tax bracket you've never been in before, new stratospheres. And then finally, well, not finally, Chapter 128. We'll talk a little bit about that today, maybe. And Chapter 128 is a way to pay. You can pick and choose what creditors to put into it and pay them over 3 years interest-free. That can be a really good tool when someone's being garnished and we're not ready to file a bankruptcy. It can also be a really good tool when someone just wants to pay their debts. And a lot of people do. And then, of course, there's bankruptcy. So bankruptcy, you know, I hate to ask the same questions every year because so many of you have been here before and you're going to know the answers. But I'll do it anyhow. So who knows where our bankruptcy law originates in this country? Where do we find it? Yes, you know where? Anybody want to venture where it is in the Constitution? Okay, well anyhow, we have a winner. What do we have for our guest, Kris?
Oh, I don't know, Dave.
All right, now I have in here this year, I have some Christmas stuff, so if you don't celebrate Christmas, don't take a Christmas thing. All right? But we're going to start here. It's Thanksgiving. This guy looks like he needs a thankful tree kit. Okay, tell me the grandchildren aren't going to like this, huh? Well, you're too young for grandchildren, but maybe your cousin. All right, so keep those questions and answers coming. The prizes are fabulous this year. Okay. So it's actually in Article 1 of our Constitution. The bankruptcy clause is in Article 1, the very first article in the Constitution. I'm very fond of saying that the Founding Fathers knew what they were doing. They put bankruptcy in there, although if you read the Federalist Papers, there's very little discussion of bankruptcy. There's some discussion about we don't want a death penalty when people owe credit cards. No, there isn't. There were no credit cards in 1776. But there is a discussion about the death penalty, and that they were concerned that we would carry that over because in Europe, there could be death penalties. And of course, at that time, there was debtor's prison, and there was indentured servitude. If you think back to Charles Dickens, like Oliver Twist, some of the books that were written back then, things were not so good when you owed money. So the Founding Fathers are coming here to America. We're starting a system with a free market economy. We all know that in free market economies, there are winners and there are losers. And losers owe money. And we're not going to put them in prison, and we're not going to behead them, and we're not going to make them sell their children. So what are we going to do? We're going to give them a way to start over. And it has proven, it's counterintuitive, but I believe I can prove to you that getting rid of your debts is a really good thing for our economy. It has employed millions and millions of people, and I will just give you a few examples. H.J. Heinz, the John Kerry fortune, Walt Disney, J.C. Penney, Henry Ford, all people who had these financial problems, cleaned it up and started over, in some cases more than once. Henry Ford, the Ford Motor Company that we know today, is actually the third Ford Motor Company, not even the second. So just those few businesses alone, Disney and Ford alone, are millions and millions of people who had jobs who wouldn't have ever had jobs if Henry Ford had gone to prison instead for his debts. So I would urge you to think about bankruptcy in a little bit different way. And one of the reasons I want you to think about bankruptcy in a positive way is because the people who come to you do not. It took me a long time to realize that when people come to me, I need to think about things a little bit differently. They never want to come to see us, okay? If you do bankruptcy work, you are the last person that your client wants to see. To them, it is an admission of failure, a personal failure when they come to see us. So it's really important, I think, when we're doing our initial interview, to let them vent. I always like to let my client explain to me, even though I've heard it over and over, they need a chance, an opportunity to explain that they are good people. They all want to say, I wasn't brought up this way. I pay my debts. And let them say that. Talk to them. Let them get that out, because that's really important to them. And you're not their therapist, so you're not going to let them go on and on for an hour about it, but you have to let them get that out, and you have to assure them that what they're doing is okay and that it is fine and proper. And so you can use some of the stuff I just told you to get there, because I find when I talk about the Constitution and Henry Ford and Walt Disney, they feel better. Okay? It makes them feel like they're okay, and they are okay. So we'll come back to the interview a little bit later. Let's start with an overview of bankruptcy. How many of you have already filed a bankruptcy case? A few of you have gone bankrupt. Okay. So not many, not a large percentage of the room. We're going to give you the framework today to do it. Maybe it's intimidating before you've done it, but it really isn't. Bankruptcy is an administrative process in a lot of respects. It's all paperwork, and the forms are already there. They're designed by Congress and the Judicial Commission, so it's not all that difficult to do. It is, in fact, I tell people that bankruptcy is an intensive fact collection. That's what it is. We're collecting information. If you get the information, it all works. So let's start with what kind of bankruptcies you're going to run into. There are several different kinds of bankruptcy. So remember my toolbox, the various things I have available? When I get to bankruptcy, I've got various tools in there because there's different chapters. I mentioned Chapter 12, that's a farm reorganization. We're done talking about that. And that's because there's only 20 of those cases a year in this whole state. We're not going to talk about Chapter 11. That's General Motors, Kmart, Owens Corning, every airline except Southwest. We're not going to talk about that because there's only, again, a relative handful of those cases, and you're not going to get one of those through VLP, more than likely. And if you did, the Supreme Court should give you a lot of CLE credit because you're going to do a lot of work on that case. And we're not going to talk about Chapter 9 because that's Detroit. That's Orange County. That's municipal bankruptcies. I did a presentation this summer to Corporation Counsel from around the state. They have a convention of their own. And I pleaded with them to please somebody do a Chapter 9 and let me do it for them because I think that'd be really fun. But we're not going to talk about that either. We're going to talk about the two kinds of bankruptcy that you are likely to run into. Chapter 7, which in Wisconsin is about 70% of all the cases,
right.
and Chapter 13, which is about the other 30%. And all the rest of the cases make up less than 1%. So we're not going to talk about the 1/10 of 1%. So, Chapter 7, sometimes called a liquidation. Normally, nothing really gets liquidated. It is the most popular form of bankruptcy because it is the, help me, fastest. There's two more.
Most comprehensive.
Not most comprehensive. Cheapest. Who said that one? Okay, we got two prizes, Kris.
All right.
2 candy bars. Yes, sir. That's true, but it wasn't what I was looking at. Fastest, easiest, and, oh wait, fastest. Oh, I just said easiest. God, I'm terrible at this.
I'm not giving you a candy bar.
Fastest, easiest, and least expensive. I don't like the word cheapest. I like least expensive.
I'm not sure who answered.
These,
There?
that
Very good.
good-looking blonde woman and this distinguished-looking gentleman.
Yeah,
So,
well,
what's not to like? Fastest, easiest, and least expensive. So let's figure out how fast is it? Well, you're in and out in less than 4 months. How many other lawsuits can you have in Wisconsin where you're in and out in less than 4 months? That's pretty good. Easy. It really is easy. You can tell your clients that they will never see a judge. They will never see a courtroom. Their testimony will consist of sitting at a table like you guys are here and answering questions for about 4 minutes. That's their total involvement with the legal system in 97% of the cases or more. So very easy in that respect. It's a lot of paperwork, lots and lots and lots of information to gather, but it's not difficult. There's just a lot of it. And least expensive. Well, BLP, it's really cool. It's no expensive. Okay? But even if they were paying, it would be the least expensive alternative. So how does it work? We file the case. Actually, why don't you walk
well, I
through
was
the
going
procedure?
to say it's not, well, I mean, how it works, if you want to start with interviewing your client and getting information, that's where it starts. We had a set of bankruptcy schedules in the back of your materials just so that you guys understand what are the current forms that are being used and what are the types of things that you need to make sure that you get from your clients. We also, it's good to use a checklist. If you don't have a checklist, and we can provide an example for you. If you guys give us a card, we can get you a checklist that a lot of times our law firm will use as an initial interview with the client to get some sense of when, like David said, we're talking to the client, we're trying to understand from the client what happened, what was the financial circumstances that arose that caused them to incur the debt, or cause them to be unable to pay their car loan right now, or fall behind in their mortgage, things of that nature. Let them vent. There's a lot of times where the clients look at me and say, have you had anybody like me before? Yes, you know, they need to know that they're not the only ones out there. But then what you're doing after you've understood what are their circumstances, you've got to start getting all the facts from them. So in the back of the materials here, and starting, if you want to just look at those, starting on page 129 of your materials are a lot of the schedules and statements. So you're going to find out if they have any real estate, right? You need to know what assets that they have so that you know that you can protect those assets and claim and from any kind of collection. In Chapter 7 case, you're looking at trying to make sure that these people have a no asset Chapter 7. That all of the equity that they have in their assets are exempt from collection by a trustee. So you're going to use, if you don't otherwise have an intake form, you're at least going to use the schedules and statements. You're going to want to know if they have any real estate. Okay? Is
And
the real
that's
estate
page 138 would be where the real estate is.
All right. Starting with 138. So you're going to want to know, do they have any real estate? Is the real estate their homestead? What do they think the value of that real estate is? Okay, they can rely upon the real estate tax bill, that's fine. Do they have an opinion other than what the real estate tax bill has? Sometimes I'll ask clients, has your neighbor or anybody in your neighborhood recently sold their home? Do you know how much they've sold it for? Is it a comparable home? To just get some sense of the value of the home. Then you're going to learn about, in connection with the home, are there any liens on the home? So you're going to be finding out, okay, who is the creditor that has the lien on the home? Making sure you get a copy of the recorded real estate mortgage to make sure that real estate mortgage has been properly signed. You're going to be getting other information about all of their personal property. Do they own any cars? Do they own what kind of bank accounts do they have? Do they have retirement accounts? Life insurance? All of those kinds of things to make sure as you're walking through the bankruptcy schedules and statements to make sure that they answer those things. Household goods. Getting all of the information. And I have a lot of clients who say, really? You want to know whether I have a TV? Yeah, I need to know if you have a TV. You want to know if I have a dresser? I have to put down everything in my bedroom? Yeah, I need to know about the dresser. I mean, I need to have some idea here that your overall household items fit within the exemptions that you're allowed to claim under the law, and that you don't have some big item out there that you just purchased, the big entertainment center that you purchased on some credit card or whatever real recently. So you need to understand all of the assets that they own. You'll want to go through and, again, not only talk about do they have a mortgage, again, not only getting a copy of the recorded real estate or recorded mortgage, getting a copy of the current balance to verify that what they tell you is owed on the mortgage is in fact the balance that's listed by the lender. Car loans. You're going to want to get the car loan documents. You're going to want to make sure that those car loan documents provide a security agreement, that they actually gave a security interest in that car when they got that car loan. You're going to want to get the title to the vehicles, or at this case now, you can't get the titles because if they've bought the car, I think within the last 4 or 5 years, the titles don't go to the borrower anymore. They go to the secured lender. But it's very easily to go on DOT, on the Department of Transportation website, and be able to put in, if you have the VIN number of the car that your client owns, put in the VIN number. It will spit out then, it will show you who the lien holder is so that you can verify that that car lender is in fact the lien holder on the vehicle. You're going to get other information from them. You'll want to get at least their 2 years of tax returns. So in this, if you were filing in 2016, you'd be getting their 2014 and 15 tax returns. You're going to want to verify that they don't owe any taxes to the IRS or the Wisconsin Department of Revenue, for example. That's primarily what you're going to be dealing with as far as tax authorities. And then you're also going to be wanting to get from them a copy of all of their unsecured creditors. And I think our office in general prefers to actually get the statements from the clients, because it's really important, rather than a lot of clients want to write down on a handwritten sheet of paper, and that doesn't usually give us all of the information, because you want not only the creditor and correct address. A lot of time you do need to put the account on the schedules, because sometimes you'll get letters from a creditor that says, hey, I don't know who this borrower is. So you want to have as much information from the statement, the actual statement from the creditor as possible, to put down on the schedules. And all of those kinds of things are important. You also want to make sure that not only do they give you a copy of the statements from the creditors, but you want to ask them, has anybody been trying to collect? Okay, are you starting to get collection notices from State Collection Service on behalf of ABC Hospital, Meritor Hospital or some hospital bill? Make sure, client, that you not only give me the statement from your creditors, but give me copies of any correspondence that you've been receiving from agencies that are attempting to collect that debt. Because not only do you want to make sure that you put the original creditor's name and information down, but these forms also allow you, and you'll want to make sure that you put down all of the collection agents that are starting to send all these demand letters, right? Because there's so many times where a creditor will get a notice of the bankruptcy filing and never bother to tell the collection agency of the bankruptcy filing. So the client is still calling you going, hey, State Collection Service is still calling me trying to collect this debt, and I filed bankruptcy. But if the State Collection Service and the other collectors get the notice directly, It's another way of stopping the stress for your client and making sure that all of the interested parties that should know about the bankruptcy case have in fact been informed. Other things that you want to make sure you'll get from your clients is the 6 months worth of pay stubs. God, they hate that. They look at me and go, I didn't keep my 6 months worth of pay stubs. Go to your HR department from your employer. I need 6 months of pay stubs. We need at least 60 days of pay stubs before, in front of the bank, or that occurred right before the bankruptcy was filed. We actually have to file those with the court. I need the pay stubs. You're using the pay stubs for several different things. You're using it certainly to verify their income, because you have Schedule I in the materials, which you have to lay out what is the income. In a Chapter 7, the income is a snapshot, right? You're not trying to project out what they might have. You do have some responsibility in the form. It will ask you if the client believes that they're going to have an increase or even a decrease in their income. But the only way for you to verify that the client is giving you accurate information is to make sure that you get those pay stubs. And then you can also provide for, now the pay stubs, you've got them, and you can provide in Schedule I, not only are you listing the gross income, but you're providing for all of the deductions. Well, how can you, the only way to do the deductions accurately for them is to get a copy of the pay stubs, making sure that the child support is part of the deduction. That's the other thing you need to ask them about. Make sure that you're asking them in your initial intake, have they ever, if you're coming in with a single person, have they ever been married? There's a lot of things these clients don't even think of because they're so nervous coming into you at the initial meeting. So make sure that you want to make sure that whether they have any kind of domestic support obligation, paternity, divorce. Do they owe, are they required to pay child support? Are they required to pay what used to be called alimony, now maintenance? I still call it alimony. And get that information. If they are in fact required, you want to make sure you get a copy of the court order so that you can accurately, you're required then to notify the ex-spouse, for example, who it has to be notified of the bankruptcy filing. Yeah?
Are all student loans non-dischargeable, loans taken up by the debtor or by a parent of a child? Are they all non-dischargeable?
Currently, yes. But what's really interesting, and I wanted to talk about that, and you're kind of skipping ahead with student loans, but that's cool because it's a really great subject, and a lot of clients are faced with that. It's very interesting. There are minority cases that talk about, I'm not talking about the student now, there's no question that the student borrower who got the educational benefit, okay, took out that $20,000 loan, gave it to UW-Madison, although that's pretty low probably that I'm saying, but gave it to UW-Madison to go to school. That student is getting that educational benefit from that loan. Now when you're talking about a parent who is the co-borrower, a co-signer, the minority of cases start to really look at the legislative history and go, wait a minute, this was all about educational benefit. We should really be looking at the fact that the co-signer didn't get the educational benefit. Unfortunately, the majority of cases say, sorry, so sad, co-signers, it doesn't really matter. The identity of the person going to school, it has everything to do with the identity of the loan. The loan was given for an educational benefit. Whether the co-signer got the benefit or whether the student got the benefit, we don't care. However, we were just recently learned, the American Bankruptcy Institute had an article. It said there's a New York case and another set of cases that have just started kind of getting this minority case, kind of starting to talk about that again. So it's something very interesting to look at. But unfortunately, right now, it is that the co-signers are still on the hook. And undue hardship is a really hard, where you can get a student loan as a non-dischargeable debt is to prove undue hardship. And that's been historically, that's been a really tough thing to show. Okay, that has to do with your client who has a severe medical issue that's going to cause them not to ever be able to work, things of that nature. And there's all kinds of information in our materials more about the case law associated with that undue hardship, the development that's happening with the undue hardship law, trying to move a little bit away from this very hard, you have to be a quadriplegic and you have to not be able to work, and this whole very strict view of what undue hardship is and strict set of circumstances. They're trying to soften it a little bit, but it's still something that's you know, you're going to be in a case-by-case basis and looking at your client's situation to know whether they even qualify for that kind of undue hardship dischargeability. Yeah.
Hi, I'm Stacia. I work in the Maxon office, and I teach the consumer law and bankruptcy policy. I'll say with those, sometimes we're helping people, not with a bankruptcy, but if they are disabled, but trying to get a disability discharge if it's a federal loan for development. So we do need volunteers for that too, because even though it's not a legal process, it can be them, you know, if someone's disabled and has a hard time with paperwork, it can be really difficult to fill out this paperwork to ask for a discharge. If you've ever had any kind of contact with the government, you can imagine what these forms might look like. And so, if it's not a bankruptcy, there might be another option, and we could use help with that too.
Yep, we
And
do
that's
have,
a good way of doing it. It is easier, Stacia, you're right, I think you're right, that it's easier to go through the Department of Education. Now, that's only going to work, though, on the federal loans. It won't work with the private loan. So first thing with student loans is you got to figure out what kind of loan do we have here. That's your first step. If it is a federal loan and there is some sort of physical disability, that is an excellent way to look at it. It's far easier to prove that than it is to prove it in bankruptcy court. Another thing is ITT just closed. So, and Corinthian a few months ago. So when those things happen, a lot of those people are not going to have to pay their student loans. So there are other exceptions. Litigation sometimes is a good way of dealing with student loans. By the way, before I forget,
explain Corinthian a little bit more when you're,
I will, but it's hunting season, so you get Bambi's father. Okay, there you go. Yeah, so when these private for-profit schools close, those people are more than likely. There's an article in our last month's newsletter, so if you want to read it, give me your business card, I'll send it to you. But those people probably will not have to pay their student loans. It depends. If they can transfer their credits, they will still be on the hook for the student loan. Another way to handle student loans is to litigate. With these, especially with the private loans. Don't just roll over, fight them. One of the strategies we employ, we've got several cases in the office right now where they sued, we defended, we got to the point where we figured we were going to lose, so we filed a Chapter 13. Well, in the Chapter 13, the lender is going to get next to nothing for 5 years. They're going to get probably zero for 5 years. So now that we've been in it about 6 months, we go to the lender and we say, you know, here's what you're going to get for the next 4.5 years. Wouldn't you like to cut a deal with us? And then if they cut a deal, we'll dismiss the 13, have our deal. So Chapter 13 can be an effective negotiating lever when we're dealing with student loans.
even, I've had a couple of cases that I've been successful with where at least I have lawyers on the other side who know that a Chapter 13 could be a likelihood. I will give them the calculations. I'll walk through, I will show them the calculations and say, you know, if we're in the 13, this is all you're going to get. You know, my client can afford, instead of taking that other 10% off that the trustee would get, my client could afford to pay you directly a little bit more, but if otherwise you're stuck with this, and I've had some success where they enter into a stipulation in the lawsuit, dismiss the lawsuit, and keep it dismissed so long as the client makes payments. So I've had one client where it worked really well, it was a parent. The other one, it was a parent also. Unfortunately, both areas were parents, and the kid informally is willing to kick in and help the parent pay it. But I've had some success with threatening the Chapter 13 beforehand, giving them the calculations and getting them to dismiss their case.
And then there's people who are my age or close who could file successive 13s. I'm going to file a Chapter 13 now, you're going to get nothing for 5 years. Then when I'm done, I'm going to file another one. And then I'm going to retire. And you're going to get nothing because I'm on Social Security. So we just want to use the system to get leverage to cut deals.
Right.
Yes, sir.
I'm wondering if I could go back to your sort of recitation of all of the things that you should look at before we got on student loans. And
Okay.
You said there was a checklist, and I imagine what you were running down kind of was a mental checklist, of course.
Yep.
But
And the schedules, yep.
I'm not sure I'm the only person in the room with some of wondering if you had any thoughts about whether that checklist or maybe an edited version of the checklist could be given to the client before the first meeting, or do you really have to let them vent and have that whole process, you know, and then basically have them take the list home and bring it back to the second meeting?
A lot of times what I do is I will make sure in our office we have somebody that does a lot of intake for us. And so what she'll do is she'll go ahead and at least send to the client a statement of assets form.
Okay.
I don't find the way the forms are set up and at least that we have to file with the court to be the easiest for a client to just be able to lay out, you know, what their household items or things like that are. So yes, there are usually, I find it very helpful, or if I'm doing the initial meeting and I finally get a lay of the land at that initial meeting of where we're going to go with this client, then I will go ahead and give them the statement of assets form. I'll give them a living expense sheet that I want them to complete. I don't need them to fill out the income part because I really want to rely upon those pay stubs, not what they put down on that income statement. And I will usually send them away with several of those things for them to go ahead and fill out. Most people are willing to go ahead and fill those out, scan them back to us so that I have some information without having to take a lot of time at that first meeting to walk through all of those kinds of things. But I usually know in the first meeting, and I'll generally give them not only the forms, but I'll give them a list. Okay, this is what I need. I need your first mortgage and a statement. And I'll make sure that they have that, so that then, and I'll give them a date. Okay, depending on what pressure is going on in their life that caused them to come to me to begin with. All right, is this something, Mr. Client, that you can get done in a week? Can we expect to get this back from you in 7 days? And then you've got that substantive, now you've got that and you can start to evaluate, is that Chapter 7 an option? But yes, that's what usually we do.
I think most bankruptcy lawyers use questionnaires, packets. We use software, we use Best Case software. Most bankruptcy lawyers in Wisconsin use Best Case. There's other brands, but Best Case is probably the most popular. I don't know if copyright law prohibits us from sending that to you, so I don't want to make that offer and then violate some law. But if not, we can probably find you a different questionnaire. But that is how I think, certainly most people who work on a flat fee basis, most lawyers will give their client a packet, a questionnaire to fill out and either bring to the initial meeting, or they come to the initial meeting and they leave with the questionnaire to fill out. And that is a very effective way of doing this. Kris has been going through the schedules, which is how I learned to do it. I just took the bankruptcy. There were no questionnaires back when I started doing this stuff. I'm older than dirt. And so we had carbon forms, and I would hand write all the information there, and my bankruptcy schedules were done while I sat at the meeting. But that's an excellent question, and I'm going to give you an orb. I want you to, not everybody gets an orb.
Is it? I don't think what's an orb?
This is an orb.
That looks like a Christmas decoration.
Be careful with that. No, that's an orb. Okay.
What generation are you from that you would call that an orb?
There's an old Moody Blues song that has the word orb in it,
okay.
Right?
All right, we'll work with that. But the only comment that I would make is that, yes, questionnaire beforehand is good, but I think a lot of these clients are so nervous and they don't even know what's important, that I really think, at least from my own experience, is that having them come in and just kind of understand the context of why I'm asking it from them is my point of view. I find, go ahead.
A lot of times my clients won't open their mail for 6 months, and it's all in a box. And I say, just bring me everything you have. If it's 3 grocery bags or 4, but I don't care. But I have to know, and I know you're too upset about this. I do a lot of elderly. And I said, just bring it to me. Let me open it, let me lay it out, and then come back in a week, and I'll start talking to you about it. So just take it off your shoulders, give it to me, and we'll start from there. Because otherwise you are going to miss stuff, and then you got to amend, and it's $30 an amendment. If you have a creditor, you have to add. And most of mine start crying.
Yeah.
I even had one cry at the meeting of creditors. Luckily, I had Brenda Zedden, who was really good with her. But, it's really that traumatic for these folks. And you really don't want to miss somebody I think, David, once you miss them, you miss them. And especially with an elderly person, I don't want them ever to have to deal with this again.
And you're right, Barb. A lot of people are depressed.
Yeah.
Financial problems drive depression, and I've had the same experience. They cannot even open. I had people yesterday. When they left, I look in their bag, and there's all these unopened envelopes. They cannot even open their mail. And that ties into what you're talking about, Kris. If they're under pressure, they feel bad. There's a lot going on with them. And I've had that same experience, the box. The best guy was the 2 lawn and leaf bags. Full of unopened mail. It's just great.
But I also, when they hand it over to you, they do seem to have they feel relieved. I can't deal with this. Please deal with it. And they just seem to be so relieved to just kind of give that ownership of all that stuff that's giving them so much stress over to a third party,
That's why you're invaluable to them.
Right.
Thank you.
Lunch.
So, that's why I encourage you to do one at least, because you really do start somebody's life over and really get them over the hump and beyond the depression, because it's amazing.
Now, one point that you had made, though, that I want to just make clear is that in a Chapter 7, keep in mind, if a client misses a creditor, okay, which sometimes happens, all right, it's not the end of the world,
No.
okay? In Chapter 7, and now we have, in Chapter 7, if the Chapter 7 trustee looks at all the bankruptcy schedules and statements that you've prepared on behalf of your client, has taken the testimony of your client at the meeting of creditors, and determines that the client has all of the assets the client owns are exempt from collection by that trustee, then that trustee issues a no asset report. Now that no asset report, that your client doesn't see it, you see it when you receive it electronically. Case law is clear out there, both in the Eastern District and the Western District of Wisconsin, that if you have an unscheduled debt, okay, let's say 3 months from now, your elderly client comes in and goes, "Oh my God, the lawn care bill! I forgot to list this guy." They're okay.
Yeah.
They're okay. If it's an unscheduled debt that would otherwise, they don't have a right, the creditor, let's say the creditor is just owed money. It's not based upon money owed by fraud. There's no non-dischargeability issues there. It's a simple matter. We have a letter that we send to the creditor if they start any kind of action against the debtor, notifying them of the case law and the fact that that debt is in fact discharged, despite the fact that it was unscheduled at the time of the bankruptcy filing.
Yeah, I've got that letter.
Yep. So just to make that clear for everybody. I kind of forgot where I left off. I think I was on Schedule I and J. So what I usually do too is then you also want to see what are their expenses. You want to understand very well who is their household members. Make sure that in your intake you're understanding what is their marital status, divorce status, who is living in their household. Is it just their kids? You'll kind of learn as making sure there's nobody else in the household that's there. They don't have their sister staying with them or anything like that. Then you're having them also fill out Schedule J, which is in our materials, and you'll want to that is one form that I give to the clients. I'll send them home after I've met with them. Okay, I need to know. Make sure that you give us your average, your utilities, food, all of the different things. I'll tell them. The Schedule J is only a group of expenses. If there's any kind of expenses that you have that are not listed on Schedule J, put it on a sheet of paper. But to try to get them to lay out what their budget, what their monthly budget is. Because you also want to be able to look at, most of your clients are going to be in a situation where their disposable income, their net income after taxes, insurance, and things like that, is likely to be less than their living expenses, right? That's usually how they end up. There's sometimes where clients have a little bit of excess, which I wouldn't worry too much about. That's kind of a case-by-case basis. Go ahead.
So you don't go over Schedule J with them at all?
Yeah, I do. It's
with the initial, because I find out typically that people have never done a budget before. It's the first time they've actually sit down and actually hear what their opinion is. When we go over their expenses, they typically underestimate the food and clothing, transportation.
And I don't disagree with you. I mean, it's a lot of times what we try to do is send the Schedule J to them before the meeting. I totally understand what you're saying. There are so many different times where the client, I get a Schedule J back from the client, and virtually 50% of all the sections aren't even filled out. They don't even know how to really estimate what they have for food. So I completely agree with you. There's so many times where, and I'm on the phone. It depends on the circumstances. I'm sure that for you guys, probably it is a matter that maybe Schedule J should be something that's gone over at the first meeting. We sometimes go ahead and send it to the client before the initial meeting, so they bring it to me, and then I see all the different areas that they're missing in their budget, and then I do talk to them about it at that initial meeting. Or I get some sense of whether that's something that's going to be really important to know. There's some people where you just can kind of see from the information they've provided that it's likely that their budget is very upside down. But I don't disagree with you that having that as part of your first or no later than your second interview is important.
A lot of times people are going to say exactly what you said. I don't know what I spend on this. They don't know, and they're being honest with you. I just tell them, don't worry about it. Put down what you think, take a stab at it, don't worry about it, because when I see it, I'll have a pretty good idea if it's reasonable or not. If they're telling me that for a family of 4 they spend $120 on food, I know they're wrong. It's the same way when they're listing their assets. People tend to think that their stuff is, all of us are probably guilty of this, we think our stuff is worth more than it is. So people will tell me that their clothing is worth $6,000. I say, no, it's not, okay? So usually we as lawyers have a much better sense of budgeting than our clients do. So it isn't usually that difficult to look at it and say, you're probably off on this. And it's going to be rare that people have any kind of a surplus of income that we're going to worry about for VLP clients. Because even if it shows a surplus or a break even, they probably haven't been to the dentist for 3 years because there's things that they've been letting go. If they own a home, they've probably been deferring maintenance before they come to see us. So it isn't that difficult for us as lawyers to help them find expenses that they weren't even thinking about. I just tell them take a stab at it. I just assure them it'll all be fine. Just give me your best guess. I think that's what I find most efficient.
Okay.
Sorry.
Any other questions at all on any of the schedules that we've talked about so far? So then we have the other thing. Did you want to interrupt?
No, you go ahead.
You sure? I'm just asking. The other thing that you have to fill out, and this is something I would not give to the clients because this will just blow their heads off, is a statement of financial affairs. Because this is a lot of historical information which you can basically help them. Most of the time what I do is I've given them the kind of core things that we've talked about already this morning, and I don't burden them with the statement of financial affairs because by the time I get the information that I need to do really the substantive assessments, I know for the most part what the statement of financial affairs is going to look like. I make sure that I ask them the questions, but if I get their tax returns, I'm going to be able to answer the first several questions in the statement of financial affairs in any event. The statement of financial affairs in general is a questionnaire talking about historical things. Have you transferred anything by sale, gift, deed, or otherwise in the last 2 years? Have you made any payments to family members? It always says insiders, but in your situation, for the most part, family members in the last year. Now, those are some questions that usually I'll ask at the beginning just to make sure that I don't have a loan to a parent that's recently been paid. But the statement of financial affairs, it's a lot of historical information related to have you transferred anything by sale, gift, deed, or otherwise? Have you paid any family members in the last year? Some of the other things, they'll ask you if you have security deposits or savings accounts. That's not a savings account. What am I thinking of? Safe deposit box.
What have you paid your lawyer?
What have you paid the lawyer?
Any other professional? What was your income for the last 3 years?
Which
what
is how you can
lawsuits
answer
have you
that.
been in? It goes on and on.
And usually when I do the asset piece, or the lawsuit piece, I've also looked at CCAP to see if they're involved with anything. So before I
Always
even
check CCAP.
Right. And
It's so easy to do, and you should just always do it on your own.
And most of the time, I check that before I even have the initial meeting with the client. You know, I'll have either my paralegal or myself go on and check to see what pending lawsuits are there. So those are questions that they have to answer. But again, it's something that generally you can help them complete. Making sure that they don't have any financial accounts that they've closed in the last year. There's questions about whether there's been any repossessions or foreclosures. Well, you're generally going to know that by having checked CCAP yourself to see what kind of legal action that they were faced with.
I think the main thing is you go through the statement of affairs with them. I think Kris is right. I don't like to just give that to them because there's legalese in there and they don't understand what it all
Right.
is. So just sit down with them, go through it, and that works. I'm going to give you a quick checklist of 5 things that I want you to cover when you have your meeting with the client. That are not necessarily in the schedules. They are, but you think about these sort of independently. 5 things that I think you want to cover. One is eligibility. Is this client eligible for bankruptcy, and what kind of and are they eligible for the kind of bankruptcy I want to get them into? Because not everyone is eligible for everything. Chapter 7 is very broad. Certainly any person can file a Chapter 7, provided that they haven't been in another bankruptcy case that was dismissed within 180 days prior to that filing. So in addition to CCAP, one of the things we always do is we check PACER. Anybody here who doesn't know how to check PACER? You can own up to it if you don't. Do we have that in
Well,
our
you know
materials?
you guys understand what we refer to as PACER, right?
Yeah, that's the federal CCAP. Do we have the connection information in our materials for that?
We do. It's not right
Okay,
where
good.
in the Chapter 7
So we always
stuff.
check PACER. We want to know about every prior bankruptcy to see if they're going to be eligible or when they're eligible for another one. I have a case last week that came in, and the client's going to be eligible November 14th or something. So he wasn't ready when he came in, but he's ready in only a week. Yes, sir.
Speaking of PACER, I know people that have old employers logins for it, and I know you can go to the courthouse to get it, their federal courthouse, but is there low cost or?
Yes, there is. Instead of PACER, you can do VCIS, Voice Case Information Service. Is that in our materials?
I don't think so, but
Okay.
I can get that for you.
Give me your email. We'll send you how to do that. I don't, off the top of my head, I don't know the number. Okay, but VCIS, you can, it's a telephone. You can call on the phone, plug in the name or the social security number, and you can get it telephonically rather than electronically. But I don't know the number off the top of my head. So eligibility, and then eligibility for different chapters. So, for example, in a Chapter 13, only a natural person, someone like you, can file a 13, but your LLC cannot. So we have to think about eligibility. That's one of the 5. The next one I want you to always think about is your residency, because we're a very mobile society. People move a lot. And when we're talking about CCAP, if somebody moved here from Illinois, and I just saw a statistic, the state Wisconsinites move to the most is Texas. The state that comes here the most, I believe, is Illinois. So they're discovering the truth. But they want to be Packer fans, that's all. It's okay. So if they've moved, changed states, it doesn't have to be anywhere. Within the last 2 years, it's really important that you know that, because that could affect their eligibility for venue for up to at least 91 days. So where they reside and have resided can be really important. And there's a complex set of rules about what exemptions they're going to be entitled to. And that goes back a whole 2 years that we have to know about. So you have to ask about residency. That's number 2. Number 3, you want to think about discharge. We haven't gotten to that yet, and we will today. But are these people going to have discharge issues or dischargeability issues? They're coming to us to get rid of debts. usually. There are other uses for bankruptcy. But most of the people are coming here to get rid of debts, and we want to make sure they're going to be able to get rid of these debts. So as you're having your interview and you're learning about your client, it's important to keep in mind the kinds of debts that might not be dischargeable, or the kinds of actions your client may have engaged in that might lead to denial of a discharge entirely. So that's number 3. Number 4.
Well, why don't you
Yes.
expand? Do you understand some of the actions that would cause clients to be faced with non-dischargeability would be things like going out and getting a big cash advance from a credit card company potentially?
I was going to come to those
Okay.
later today.
All right, sounds
rather
good.
than go into all that right now. But you're right.
Okay.
So that's 3. Number 4, exemptions. What do our clients get to keep as they go through this process? And Kris mentioned no asset reports. In the vast majority of cases, well over 90%, they keep everything. Okay?
They
So a
meaning
lot
the
of
debtor. They meaning the debtor.
They, the debtor. Your client will keep everything. Well, why is that? We're going to cover exemptions a little later, but it's because the debtor's entitled to keep certain kinds and types of property up to certain values. We all get to do that. You are entitled to exemptions right now. Your many creditors that are waiting out in the lobby can't take everything away from you, okay? So because under Wisconsin law, we have exemptions. When Kris is filling out Schedule C in this bankruptcy schedule, she chooses from state and federal. But you have to be thinking about, how am I going to protect my client's assets? That's number 4. Number 5, the last thing, or last segment of things I want you to think about when you're meeting with your client and you're preparing this stuff, would be transfers. Kris mentioned a couple times, have you transferred anything by sale, gift, or deed or
otherwise.
something? I use different language. I just like to know if you made any unusual transfers or gifts. But we have to be thinking about preferences and fraudulent transfers. Have you made payments to anybody in the last 90 days? And if so, is that going to pose a problem? And that doesn't have to be a payment, it could be a balance transfer. Lots of people do balance transfers with their credit cards. Fraudulent transfers. It is amazing to me how many people think that the last thing they should do before they come see me, the absolute most important thing to do, is to transfer the car or the boat or the camper to their daughter. The day before they come see me. That's really important that they do that to them. It's also the worst thing they could possibly do, okay? Because that can be a fraudulent transfer. It ties into number 3. It ties into the discharge. Could deny them a discharge. So we're going to cover all those things, I hope, and I hope you'll have lots of questions about them. But those are the 5 things that I mentally go through when I'm meeting with a client. Eligibility, residency. So I have to know how long have you lived here. That's on in fact, my assistant who does all my intake calls. She goes through all these things. Residency, eligibility, discharge and dischargeability issues, exemptions and preferences and transfers. Those are the things.
The other thing that you will be filling out, they have, is in a Chapter 7 setting is what we're talking about primarily. They get into the statement of intention area, and I don't know if we want to get into that in reaffirmation agreements as much. But after you've gotten your schedules and statements done, all right, with the client, then you've determined, let's say you were able to determine that all of their assets are exempt from collection, all right, and that any of the things that David just raised regarding those 5 issues do not cause a problem for the client. Then you could go ahead and you need to make sure that the client understands that they have to get credit counseling. Have you guys heard all about the credit counseling requirements that clients have to take a credit counseling course before they can file a bankruptcy case? And they have to have that certificate in your hands so that when you file your voluntary petition and other documents with the court, you also are filing a credit counseling certificate certifying that the clients have taken a credit counseling class from an approved agency, an agency that has been approved by the U.S. Trustee's Office. So I don't know if you have any questions. Go ahead.
Do you require them to have that on their first meeting when they walk in the door?
No, And the reason, no, not at all. And the reason is that when they first walk in the door, I don't know if, just like David said, we still have to go through that five-point analysis. I don't even know if they're going to file. If they come in and for some reason they've done something dumb by transferring a camper to their daughter, all right, then I don't want them to take the credit counseling course right away because that certificate only lasts for 180 days. And if as far as it being valid to file with the court as part of a bankruptcy filing. And if for some reason I have to delay for the client because they've done something goofy prior to coming and seeing me that's going to delay our filing for them, there's no point in them taking the credit counseling course, in my mind, until I've told them to go ahead and do it.
But for a pro bono case, how much work would you put in to know that they were serious and take this course?
Well, I mean, a lot of that is right. I myself, because you haven't been able to go through the analysis, you haven't gotten any of the materials from the client, I would still not have them do the credit counseling until you're confident, that a Chapter 7 or a Chapter 13 is where you're going to proceed. Because it only takes them, all of these agencies, for the most part, you can do it via phone or you can do it via internet.
I've had a lot of clients, and they're not in bankruptcy, but they're landlord-tenant cases where they just don't want to do any work and they just assume I'm going to do it and they don't have to pay an attorney. So I find myself doing a lot of work, going all the way to hearings, and what they told me wasn't true, and so I wasted 10, 20, 30 hours sometimes.
Right, and I guess that would be something that you'd have to talk to Volunteer Lawyers Projects as far as the screening that might be involved for you. And some of it may be that at the same time, when you asked me about the credit counseling certificate and telling them to take the course, until I've at least done some of that analysis and are confident that a bankruptcy is what I'm going to do, I wouldn't have them take the course prior to them seeing me at my initial meeting.
Okay. It just seemed like a very good faith thing they could do for not much.
Yeah, I mean, they can do it for the cheap. I mean, I always tell clients, go with the cheapest credit counseling agency because they're all certified. All of those agencies are certified to give the same course. So why pay $40 to an agency for the same course that you can pay another agency for $10?
And if the debtor is indigent, they're required to do it for free.
Right, right.
Good question. I think that deserves the Christmas, no, it's not Christmas, the snowman tumbler. These are good for old fashions.
Does it change color when you put bourbon in it?
I have no idea, but let's try it at noon.
All right.
All right. So now we've talked a whole lot about how we get started. Let's walk you through a quick Chapter 7 process. Remember, it's fast, it's easy, and it's inexpensive. So we've done our work, we're ready to go, we file our case. Probably you're doing this electronically. You'll get an immediate notification that you can send out to creditors, stop the garnishment, get the car back, whatever it is you have to do. You're going to get a notice, again, almost instantaneously of the date and time and place of your meeting of creditors. Clients tend to get really nervous about meetings of creditors because it sounds scary. My creditors are going to be there? Are they going to hit me? What are they going to do to me? Okay? Well, they're not going to do anything. In fact, they're not even going to show up. Okay? So I can tell clients that although it's called a meeting of creditors, it is highly unlikely that any creditors will show. You're going to be there 4 minutes. Well, you might be there an hour and 4 minutes waiting for your turn, but when it is your turn and you're talking to the trustee, you're going to talk to him about 4 minutes. So I have to tell them about the trustee. The trustee is the representative of the Department of Justice, whose job is to go through those schedules and ask a few questions, make sure everything looks appropriate and proper. Chapter 7 trustees, remember we're talking Chapter 7 here, get paid on what they can find. What kind of assets can they get their hands on to distribute to creditors? So they have an incentive to go, I call them scratch and sniff trustees. They're out scratching and sniffing, looking for ways to make money because they don't make any money being a trustee. The trustees get $60, I think, for
65,
a
I
case.
think.
They'd be far better off in their offices billing at $380 an hour than taking this trustee work. The reason they do it is that when they find an asset that they can work on or a cause of action to pursue, they hire themselves as the counsel. Now they can charge their $380 an hour by the hour, and then they get a commission based on what they collect. So they're out there looking for ways to get assets. Our job is to make sure they don't get anything. That's my, usually. There are ways that you might want to let them have money to pay taxes or something, but
Can I interrupt you?
generally we don't want them to get anything.
Right. I wanted to interrupt, though. He mentions causes of action. I didn't talk about that in Schedule B. So if you have clients particularly coming in, let's say, where they have a workers' comp claim or something like that, make sure that you're listing those claims on Schedule B as well. Make sure that you're asking them about that car accident that may have caused them to not be able to pay their bills or their injury at work. Because you'll want to make sure that those causes of action are also listed on their schedules and that you're able to exempt their interest in it, so that you aren't faced with all of a sudden at the 341 meeting, the trustees go through not only the schedules, but they've got their own set of how they ask questions. And they ask questions sometimes beyond what the schedules have asked. And so just want to make sure that you're also, in your intake, verifying that the clients don't have any causes of action, or if they do, having those really specific, have them give you a lot of detail.
And ask that question more than one way. People, if you say, do you have any causes of action?
Yeah. Huh?
Okay.
What?
Do you have any claims? A lot better to say, have you ever been in a car accident? Okay. Have you ever been hurt at work? Ask that question several different ways, because the doctrine, the legal principle that Kris is referring to is called judicial estoppel. And if the debtor has not listed a personal injury claim on the bankruptcy schedules, and then they later want to go and pursue that claim, they may be judicially estopped. The Seventh Circuit has a whole line of cases on judicial estoppel. And that could turn out to be your client's greatest asset, would be this personal injury claim. In fact, that's one of the reasons that people may want to file a Chapter 13 instead of a Chapter 7. Because a Chapter 13 is going to go on, unlike Chapter 7, it's going to extend over a period of time. And during that time, maybe they'll get that personal injury claim resolved. And if it's a low enough amount that it's all exempt, fine. Then they convert to Chapter 7. If it's greater than what they can exempt, maybe they want to dismiss the 13, get the money. You're going to help them move the money into exempt assets, and then they file Chapter 7. Chapter 13 is a wonderful thing, and we're going to talk about it a whole lot here in a few minutes. But right now, we need to tell the client about the trustee. You're going to have this meeting with a trustee. They're not going to cross-examine you. The trustee's not trying to trick you. It's not like being in court where someone is cross-examining and trying to lock you into positions. The trustee's just asking questions. And to make them feel good, I tell them, you're going to know the answer to all the questions. They're going to be such difficult questions as, what is your name? Where do you live? How long have you lived there? Did you sign these schedules? Were they true and correct when you signed them? Do you have any changes to make? In fact, we have a list of what we expect the questions to be from the trustee. If you can give that to the client, they feel a lot better. Okay, oh, this is what they're going to ask me. Yeah, I can handle all that.
Or I'll call them about 5 days ahead of time. I don't talk to them even at the signing meeting, when you're going through all the schedules and statements. They're so focused on that piece of it. They really have to compartmentalize this process, and you have to help them, and you need to be aware of doing that for them. So a lot of times what I'll do is after everything's been filed, we send them a letter notifying them of the meeting. We send them a copy of all the schedules and statements that have been filed with the court. And I'll make a point of calling them about 5 days ahead of the meeting, and I will literally run through and I'll know the trustee. I'll run through the questions that they should expect the trustee to ask. Talk about how this is not an adversarial relationship. If I know the personality of the trustee, I tell them a little bit about that. Try to make them really comfortable, so by the time they get to that meeting of creditors, they really know what to expect, and they've spent time looking at their schedules, and they're not, hopefully not surprised, and hopefully I'm not surprised by anything that they say. But
And you can also tell them they'll usually not be the first one called. They'll have an opportunity to see a couple other cases, and they'll see how hopefully smooth they go. So now you have the meeting of creditors. It ends. Hopefully it's concluded. A lot of times it's not, because the trustee found something that you need to amend, something that needs to get added. That's not uncommon. Warn your client that that's not uncommon. Warn them ahead of time. That way they don't think that you're somehow the cause of this. Trust meeting finally concludes either at that day or upon you providing additional information that's been requested. And then almost within a day or two, you'll get that no asset report, which now means everything's exempt. Your client gets to keep everything. If you don't get the no asset report, that means there's something here that we got to deal with. The trustee is dealing with something. Your client then has to take the financial management course. They can't get a discharge until they go back online or on the phone and take a course. Courses are scary. My wife, the word test, okay, I remember when she was in school. Tell them it's only a course, there is no test. You cannot fail. You have to spend 45 to 50 minutes on the internet and you're done. Everybody can spend 45, 50 minutes on the internet. That's not hard. So we warn them about that. They take the course, they get the discharge order, case closed. Really simple process. That's Chapter 7 start to finish. So now let's talk about Chapter 13.
Real quick on that.
Yes.
David. I've been having problems with local county courts getting the removal of a judgment on a court case. That is, you actually have to send in these forms that the judge has to review, and they're all very different. It's really amazing between, I do rural, Juneau,
Yeah.
Tucson, Sauk, and they're really a pain. I've got two right now that I keep resubmitting, and they go, no, this isn't quite right, this isn't quite right. And usually I don't do them, I require that they do them because it's outside the scope of our contract. That is, once your discharge is obtained, the cleanup or anything thereafter is on you.
You're talking about the Wisconsin procedure to satisfy a judgment. It's 815.19 or .21, I can't remember the number.
And so they, trying to explain to them, now this doesn't automatically come on.
It's not 815, it's 806 point.
That's it.
Yeah, I'm sorry.
So I've got them going to do this because I'm, and they just get a real runaround. I mean, is there
Well,
some
we use
basic
the
form?
same, okay, I've never encountered that problem, and I do all those counties you do.
Yeah.
And we use the same form, but we send them in for the client. And we do not have problems getting that at all.
Maybe that's what I need.
If you don't know what we're talking about, under Wisconsin law, and we're somewhat unique, I'm not aware of any other state that does it, under Wisconsin law, this is not part of your bankruptcy case, which is why lawyers like Barb exclude it from their fee agreements. But under our law, it's 806, I think, .19. It says that if someone has received a bankruptcy discharge, they can apply. It's an application, it's not a lawsuit. You use the same caption as whatever the judgment was in. You send in an application to satisfy the judgment. The application is not difficult. We enclose a copy of the notice. We show the mailing matrix that shows that this creditor got notice. We include the page from the schedules that shows they were listed and how they were listed. And they're usually signed. I tell my clients expect it back within a week.
Well, and then you also use a copy of the discharge order.
And the discharge order, she's right.
But then we also have to have notice of service by mail.
That's the mailing matrix.
Yeah.
Yeah.
Yeah, well, I mean, to the creditor that you're sending.
Oh, when you're sending in the application,
Right,
yes,
you have to
yeah,
have that
of
too.
course.
The affidavit of mailing, right?
My clients almost always forget, and then you have to wait get the copy back that's signed by the judge.
Well, okay, so the problem is your client isn't following the
I
procedure
think that's it.
because we do not encounter any problems. At one time, we thought that this process could only be used for exempt assets, so things like homesteads. There is a Wisconsin case from probably now 10, 12 years ago called Megal, M-E-G-A-L, Megal Development, that says that this process, this application applies to all judgments. So even if somebody had a lake house or some family cabin, interest in a family cabin up north, you can still satisfy the judgment. The judgment gets satisfied The judgment lien is satisfied on any judgment that you apply for.
Have your client, though, send in the $5, because most of the time the judgment
I
creditors.
always remember the $5, because
Right.
the clerk always yells at me, but especially now some also are doing electronic filing.
And that's, yep, and that's going to be,
Some aren't, and that kind of goose things up a little bit on the payment, but since I've had to put money in an account all over the universe here, I've done it successfully to pay that myself.
Yeah, if you encounter that problem again, let me know. I'd be
I will.
interested in how that happens because we have not run into that.
Okay, yeah, that's what, and it was just recently, so
Yes?
it's good.
Because of this process that you're talking about, because Wisconsin has this, you don't have to do the judicial lien avoidance within the bankruptcy case to get rid of those judgment liens, correct?
That is correct. So, this young lady, she's in the advanced class. She's talking about judicial lien avoidance in bankruptcy, which can be done. One of the powers, I always like to think about when I explain bankruptcy to people, not so much Chapter 7, although it's true there too. I do a lot of business work. And so farmers and businesses, and they come in and they're concerned. The bank's foreclosing, it's going to repossess, take over the factory, whatever it is. And I explained to them that the playing field when they got the loan was like this with the bank up here. Okay? And anybody here who's ever gotten a mortgage loan or a vehicle loan, how much negotiating did you get to do? What changes did you get to make in those notes? Okay, or security agreements? Zippo. It's all drafted by bank lawyers, and it's all in favor of the bank. So what does bankruptcy do, or even the threat of bankruptcy? It takes this playing field and it starts to level it because of powers that the debtor has in bankruptcy. And one of those powers is lien avoidance. So there's different kinds of liens that can be avoided in bankruptcy. One of them is judicial liens, which are judgments that impair an exemption. So if there is a lien, a judgment lien on my homestead, which I can claim as exempt, I can then avoid that lien in bankruptcy. But to do that requires a notice and a motion and work. I don't want work. So I don't bother with avoiding judicial liens in bankruptcy in Wisconsin. In a lot of states they have to, but here we can dispense with that because of this 806.19 process, which is far easier to do. And if for any reason you couldn't get it done in the county court, you could reopen the bankruptcy court. Now you got to do even more work. You could go reopen the bankruptcy case and avoid it there. So we don't see a lot of judicial lien avoidance in bankruptcy in this state, unlike others. What we do see are lien avoidance on things like household goods. And we don't even see that much anymore. There's probably 2 or 3 of you here that are old enough to remember Thorpe Finance. Okay, yeah, you remember Thorpe Finance. They used to take liens on your refrigerator, okay? Not that they ever wanted to come get the refrigerator, but they felt that if I have a lien on the refrigerator, you're going to pay me. So we can avoid liens on household goods that would otherwise be exempt. The most common lien avoidance is probably on tools of the trade. So if you have a client that is a car mechanic and he has tools and some bank has a lien on tools, we can avoid the lien on tools provided we meet two standards. One, it cannot be a purchase money security interest. And everybody knows what a purchase money security interest is. That's a lien where I extended you the credit and I took a lien on the item you purchased with that credit. Purchase money security interest. So your car loan when you bought the new car was probably a purchase money security interest. If you had that car and you refinanced it later or took out a lien on an existing car, that's not a purchase money security interest. So we can't avoid a lien if it's a purchase money security interest, and we can't avoid a lien if it's in the possession of the creditor. So 2 things we have to worry about. So we always want to, it has to be a non-possessory security interest. So we avoid liens a lot on farm equipment,
Right,
for
that's
example,
where the most
and
biggest
on
place.
some livestock, because livestock can be exempt under Wisconsin law. So if you have a non-purchase money security interest that is impairing, that's eating into your exemption on tools, livestock, or anything else that's exempt, it can be avoided. So that's a really good question. I think that deserves I don't even know what we
I,
have.
I
in
was
here.
gonna. I didn't want to pick.
I
I knew
thought
that
that
he
was-
would have especially
No,
would
no,
want
this,
to pick.
I am so thankful to you that you're getting the thankful tree kit, and I expect to see that up and working.
Now it's 10:30, so we were going to take about a 10-minute break at this time. So why don't we go ahead and do that right now?
And the best question when you come back, don't come up here during the break, okay, because I want everybody to hear your question. The best question gets the blue orb.
It's not an orb.
Okay, we'll come back in 10 minutes. And if you don't